you ready, Ms. Courtney? Well, hold on one second, John.
Hold on one
sorry.
second, everyone. Court is on session. The Honorable Judge Stevenson presiding. There is no talking.
Thank you. Good afternoon, everyone.
David March, Joseph Walsh, Thomas Gaffney.
Okay, the record should reflect that all defendants are present on bond, and if the parties can please put their names on the record.
Good afternoon, Judge. Patricia Brown Holmes, Ron Safer, Brian Watson, and Erin, E-R-I-N, Gasparka, G-A-S-P-A-R-K-A, for the Office of the Special Prosecutor.
Good afternoon, Judge Jason McKay on behalf of David March.
Judge Todd Hughes, Tom Green, Mark Stanley. We have to do one.
Good afternoon, Judge. My name is Will Fahey. Your last name is spelled F-A-H-Y. Represent Thomas Gaffney, who is present.
We left off the other day. The defense objected to the emails. Since that time, the people have filed a memorandum in support of the court's ruling on November 5th, 2018, and the admissibility of co-conspirator statements at trial. The court has had an opportunity and is taking into consideration the arguments and objections of the defense attorneys and the argument of the special prosecutor. The court hereby overrules the defense objection regarding the emails. This ruling is consistent with the court's ruling on the state's proffer regarding co-conspirator statements. However, certain portions of the emails were not contained in the proffer. Should the state wish to publish or admit the entire document, are there any additional objections by the defense?
On behalf of David March, no additional objections. We maintain the objections already made in the record.
Okay,
Your Honor, on behalf of Joseph Walsh, we stand on our previous objections.
Judge, on behalf of Thomas Gaffney, we would also stand on our previous objections.
Your Honor, so the record is clear. What we did was we highlighted to the court the most relevant portions of the email so that the court didn't have to read through this voluminous portions, but we are moving to admit the entirety of the emails that.
then the court has a question regarding, and I don't want you to argue and state the content of the email since the court hasn't ruled on this portion yet. Tab 5. Starting with the third paragraph from the bottom. All the way to the end. Can you tell the court the relevance? And that's a portion that wasn't contained in your proffer. Just of that portion.
Your Honor, I think with regard to the first of those, so the top of the paragraphs that you identified, that is the third paragraph from the bottom.
Correct.
And the next paragraph that just starts "we."
Right.
I don't think, I think those could be excised. The last paragraph, I think, provides context for what is very relevant at the end of the next case. But those, I think, those two paragraphs that you, those first two paragraphs that you said, we could take out, and it would not affect the relevance of the exhibits.
Any further argument on that, Mr. McKay?
Huh?
Do you have any other argument
Yes, Your Honor, regarding those two paragraphs,
or the remaining paragraphs?
I want to.
They're agreeing that those two paragraphs should be redacted.
I don't agree. I don't agree.
Oh, you want them in?
Over my objection that any of these go in. If they are going in, I want them all in that.
Okay,
In their entirety.
okay. Mr. Pugh
Your
or
Honor,
Mr. Breen?
Your Honor, I think that, I'll just restate our position. I don't believe that any of this has any relevance to Joe Walsh whatsoever.
Go ahead.
That would be our objection, is that the emails have no relevance to the case against Joseph Walsh.
Mr. Fahey?
Judge, we would join in that objection. The author of the email, my client doesn't know, he wasn't a part of the email chain. He doesn't know any of the person who authored this email. He doesn't know the person that it was sent to.
And I believe those objections were made when there was argument on the co-conspirator statement. My ruling stands. It will be admitted. Then, since there's no, other than the objections you previously stated, Mr. McKay, you're saying you want the entirety of it in?
Yes, Judge, regarding this exhibit, the state wants to redact these two paragraphs. I would submit.
No, I asked,
I'm saying, I don't agree that those paragraphs should be redacted.
then they'll go in.
Thank you.
Same for you, Mr. Pugh.
Yes.
Same for you, Mr. Fahey.
Yes, Your Honor.
Okay. Tab 9. Mr. Saper, can you argue the relevance of that?
So Your Honor, first of all, it is clear that what is happening is these officers, and would you, so I'm going to speak cryptically
Sure.
until they are, because they're not in evidence.
Correct.
So, so these officers are at the very top of the email, and I'll go to the bottom in a minute, but are working to assist their fellow officer in a defense during an open investigation. And that's not, that's just not police work. That's not proper. That is a that's part of a conspiracy to conceal what has happened, to avoid prosecution. Now, if you go down, they are asking for permission to produce, I would say generally, police information to a non-police person, which is, of course, totally improper, for the benefit of disseminating that so it could help an officer who is under active investigation. Finally, at the very bottom of the second page, it identifies who that person is who is outside of the Chicago Police Department, to whom they are seeking to release this information, and from whom they are seeking to get assistance. Again, in the case to help this officer, all of which is improper.
Any further argument, Mr. McKay, other than what you've already stated? I know you object to it, well, any of the emails going in, but is there anything other than that?
No, Your Honor.
Okay, Mr. Pugh or Mr. Green or Mr. Stanley?
No, Your Honor.
Okay, Mr. Fahey?
No, Judge.
Okay, based upon that, the court's going to allow that one as well. I think that addresses the issues that the court had. So, as I said, the defense objection is respectfully overruled. So, are the parties ready then to proceed?
We are sure.
Okay, then state, call your next witness. Before the witness comes out, I just want to address something that was brought to the court's attention or file stamped. It was a letter from Natalie J. Spears, SPEARS, from Denton's US LLP, asking that the court reconsider allowing the monitor for the media to display any exhibits, or that they have a copy of the exhibits. The court has reconsidered, and the court's ruling stands that there will not be a monitor and the exhibits will not be tendered for the reasons that the court stated in an in-camera hearing with Ms. Fusco. All right, you may proceed.
Your Honor, before the state calls its next witness, the state intends to use the same exhibit books and examination that the state used previously.
Okay.
The state also, with Mr. Maris, who will be the next witness, intends to offer additional emails as public and business records, not as statements in further of a conspiracy.
Is there a stipulation regarding that?
The witness will testify to it. I wanted to hand out copies of these exhibits before providing the exhibits to the witness.
Any objections, Mr. McKay?
I need to see the.
Not to the exhibits.
I need to
just-
see the exhibit.
Okay, then show them to the defense, please. defense have an opportunity to look at did you say for the stipulation
We intend to offer it as a,
exhibit?
as a business and public record with the witness.
Okay.
It is, will be identified as CPD email 13, CPD email 14, and CPD email 15. Your Honor, I have additional copies for the court to insert and review.
All right. Have you had an opportunity to review it, Mr. McKay?
Yes, Judge.
Any objection if the court receives a copy of it now prior to the witness testifying?
I have no objection to looking at it. I have objection to the admissibility of them.
Okay, we'll take that up at the, do you want to discuss it now?
We can discuss it.
Okay, what's your objection?
Your Honor, these emails that have just been tendered to us are not relevant to the charges before the court. Exhibit number, well, tab number 15, which is CPD email 13, includes links and communication from the media in this case. That is far more prejudicial than probative, among other things. If we are convinced, if we're trying to suggest media accounts are evidence, we are in a very, very sad state of affairs when it comes to due process. So that's for tab number 15. Tab number 16, Your Honor, purports to be CPD email number 14. This again is an email that lists several links and information, again, from media outlets suggesting various things per somebody from the media. That's not evident. That's more prejudicial than probative. That's not relevant and material for the charges pending before these three innocent men. And regarding tab number 17, which is email CPD 15, this is dated December the 5th, 2015. Nowhere are these three defendants listed in this particular email, and it is so far removed from the police reports submitted in this case. This is months, several months later, that it is not relevant to the charge before this court, and is prejudicial, far more than probative regarding the charge before the court against these three men. So for those reasons, Judge, I have to object to these three exhibits being admitted.
Thank you. Mr. Pugh or Mr. Breen, Mr. Stanley?
Your Honor, I don't know. A relevancy objection has happened. It looks like a hearsay objection as well. So based upon that, I don't see relevance, particularly media stuff. But making a mistake and what the relevance